like to joke with my clients that it's a little bit like defusing a bomb, and I think about those 80s movies where the bomb squad is, huddled in the parking lot and the clock is ticking down, and, we got to make sure we cut the red wire, not the blue wire. And the reason why I make that joke is just to carry home the point that there's a lot of risk in terminating design and construction contracts, and it's not something that you want to do lightly, and it's not something that you want to do without a lot of thought ahead of time. Because what you find running through most cases that reach a lawsuit, is the court looking at the question of who breached first. And a lot of times you'll get an aggrieved party and they'll say, oh, my contractor is taking so long, I'm going to terminate them. And you got to take a step back and you got to say, okay, has the delay, just as one of many examples, risen to the level of a material breach, something that would justify the owner in terminating the agreement between the owner and the contractor. Because the question of who breached first is going to typically dictate the outcome of the case. And so, if I was asked to assess that, I would say, let's look at the contract and see what it says about schedule. And a lot of times there's, very light language around, schedule, and it's not elevated to the level of, something that is of the essence of the contract. It might be the case that, there's just a completion date and there's nothing along the lines of, and the contractor understands that the owner has a tenant, they've signed a lease, they have to get the tenant in by a certain date or they're going to breach their lease and lose their tenant. So you have to look at the contract and you have to assess, is the thing that you're contemplating as a justification to terminate the contract, does it rise to the level of a material breach of contract that would justify your terminating a contract, or is it a lower level breach, a minor annoyance, something that wouldn't result in a proper termination of contract, something where if there was a lawsuit, the court would say, who breached first? Well, the owner's legally operative act of terminating the contract, the judge might say that was the first breach. And that is how an owner or a real estate developer can open themselves up to claims that they wouldn't want to face. Because